Liability forms. When a company grants credit to a customer, it is important that the company knows who will be liable for the debt, meaning from who the company can demand payment for the goods. Secondly, the company should know which assets the customer owns and can be liable with, meaning that if the customer cannot pay his debt, the company can make outlay in these assets. For instance, a car, a summer house, or an expensive fur coat. As a debtor, you can be liable in several ways. You can be personal liable, limited liable, solidary liable, pro rata liable, directly liable, or indirectly liable. Personal liability means that the debtor can be liable with everything he or she owns, and therefore can lose his fortune if he cannot pay his bills. Limited liability means that you can only lose your investment. For instance, if you have invested 1,000 Danish kroner in a company, and the company goes bankrupt, you can only lose the invested money. The creditors cannot make outlay in your personal belongings. Solidary liability requires several debtors. This means that if one debtor cannot pay his part of the debt, the others will have to cover the debt equally. Pro rata liability means that there are more than one debtor, and it is agreed on beforehand how much each debtor is liable for, which percentage. The single person is only liable for his or her share of the debt. Direct liability means that a creditor, without prior notice, can demand payment taken from the debtor's personal fortune. Indirect liability means that a creditor first must try to get his pay from the debtor, for instance, the partnership company. Only if the debtor is insolvent, he can go to the company's owners personally. Matrimony. In Denmark, two people of the same sex or the opposite sex may enter into matrimony. You must be at least 18 years of age, and you can marry in a church or publicly. The Marriage Act on Financial Relations, popularly called the Spouses Economics Law, regulates, as the name says, spouses' wealth. The Act contains provisions on spouses' dependence, counsel, and liability, as well as spouses' internal agreements regarding separate property and how to divide their assets in case of divorce or the death of one spouse. The basic point is that the individual's right to act freely is not restricted by entering into marriage. However, the common property ownership that arises means that in a few situations there is restrictions on the parties' independent right to act freely, both in connection with debt formation and sale of assets. The Marriage Act sets out the rules that apply when marriage ends due to separation or divorce. In case of divorce, the people's common positions must be divided. The same applies when one spouse dies. Then the dead person's estate is divided among the dead person's heirs. One of the heirs is a spouse.
Before one marries, they usually own several of assets such as furniture, cars, sport equipment, housing, etc. These assets also include debt, which is considered to be a liability and therefore included into the marriage, also referred to in the Law of Spouses Economic Relations, paragraph 1 and 3. The main rule is, however, that each spouse has unlimited control over his own assets. This is known as separal control or sole management, as spouses are still considered to be two different individuals when considering law. An example of separal control could be that a spouse who owns a car can freely sell or pledge the car, or can, for example, freely take out a loan. When engaging in marriage, two individuals commit themselves to a community of property, which means that there is mutual duty of support, for example, economically, while the marriage lasts. Spouses' divisional wealth is not relevant until the marriage ceases on divorce, separation, or death, also referred to in paragraph 5, subsection 1 in the law of spouses' economic relationships. Spouses, however, may agree to changes in what should be included in the sharing of assets. The document where these are stated is known as a prenuptial agreement. Prenuptial agreements are made in order to exclude real property and make agreements on divorce. These also refers to the law of separate estate. However, it is not relevant before divorce or death. In community of property, the laws of separate control or sole management is applicable. However, there is 3 exceptions, which include real estate, a couple's home, unreasonable deterioration of shared wealth, and of course joint assets. Separate control is the main rule that gives spouses the unlimited control over his or her own housing situation. The exception of the separate liability law is, however, concerning taxes. The Danish tax administration system has implemented the possibility of recovering a tax debt from the other spouse if one fails to pay their debts. This, however, is only concerning and considered tax debts, meaning debts to the government. Spouses spouses can, of course, give each other occasional gifts such as wedding and birthday gifts. The decisive factor in whether a transfer of assets can be described as a gift is that there must be a gift intention. This means that the giver has wanted to renounce the gift without any claim for consideration. A gift.
Separate liability. No matter if two people are single, just married, or have been married for a while, the rule of separate liability stands. Marriage really has no influence on incurring debt. Physical persons are only liable for the debt they've established themselves. This is according to the Spouses Act, paragraph 3. Each spouse is liable for their own debt with their assets. The one exception of this rule concerns taxes. According to the law on taxes, the tax administration can demand tax debt from the other spouse if the debt was established during the marriage. In order to do this, the debt must have been unsuccessfully demanded from the spouse to which it belongs. This is because it gives spouses more freedom to manage their economy. For example, if one spouse is not making use of his or her whole deduction, then the other spouse can. A spouse that is personally liable for his debt is bound by everything he owns, whether it is separate estate or it belongs to the property. Here it is important to know that what the creditor's demand of the individual comes before the spouse's demand of the share of the joint property. It is often hard to determine which spouse owns an asset. Here it is the spouse's duty to prove who owns the asset. Especially household effects paid for with cash are hard to determine. Usually the party who purchased the asset will be considered the owner. If it is possible to determine to whom an asset belongs, it will be considered joint property. Hence, the spouses own the assets together. Gifts that the pair has been given together will be considered joint property. An asset can be passed on to the other spouse if an agreement of sale or purchase is made, or if it was given as a gift. If both spouses have debt together, they are jointly and severally liable. Separate estate is an exception to joint property. The difference is that separate estate is not to be shared at the termination of a marriage, but the spouse who has separate estate gets to keep all of it. In case of death, the longest living spouse will not be able to keep living in the house if it was separate estate of the person who is dead. A spouse is bound to creditors with everything he owns, regardless of joint property or separate estate. So separate estate only applies between the spouses. The spouse who has separate estate can do with it as he pleases without consent of the other spouse. Separate estate can occur in two ways: by agreement between the spouses or a third party. Often it is an agreement between the married couple. The agreement is called a prenuptial agreement, and this can be made before and during the marriage, according to paragraph 19. For the prenuptial agreement to be valid, it has to meet the following conditions of paragraph 20. It must be written down, it must be signed by both parties, and it must be registered. According to paragraph 21, a prenuptial agreement can only be revoked or changed with a new prenuptial agreement. There are three different forms of separate estate. There is divorce separate estate, which is valid in case of divorce or separation, but not in case of death. There is complete separate estate, which is valid in case of divorce, separation, and death. And then there's combination separate estate, which is valid in case of divorce and separation and becomes joint property in case of death. These agreements of separate estate can be made according to paragraph 12. If both spouses have separate estate and there is no joint property, it is called fully separate estate. And separate estate can be of fixed duration.
When we're talking about the termination of marriage, one thing that comes quite naturally is the housing division. Generally, when we speak about the termination of marriage, we have two terms, one being the separation and the other being the divorce. Where the separation is a form of what we call a trial divorce or reflection period, in which the parties are still in marriage, a divorce on the other hand resembles the final dissolution of the marriage. Separation and divorce can be granted by the state administration or be settled by the courts. Following the law of marriage and dissolution, a spouse cannot prevent the other from getting a separation or a later divorce. A termination of the marriage requires a division of the division wealth, what we call the housing division, and also the decision on who's getting the custody of any common children. We deal with the housing division both quantitatively and qualitatively. To start out with the quantitatively, we emphasize an equal distribution of the financial asset. This is, for example, stated in paragraph 5 of the Act of the Financial Affairs of Spouses. In the event of a separation or divorce, the spouses divide their assets equally unless they have entered into an agreement on the division under section 32 or otherwise follows by paragraph 26. Thus, there are special rules in the case of the spouse's death or when changing an unchanged residence. As paragraph 5 states, it requires an equal share of each spouse's and is calculated as following. Each spouse's total value of the assets is deducted from the same spouse's total liabilities. This gives us what we call the net stock. This is the profit. If this is a profit, then we divide it half to each spouse, and if it's a deficit, we simply reset it. What the spouse is entitled to is what we call the settlement. When the assets are deducted, the real value is taken as a starting point. When we're talking about liabilities, they have to be deducted from the total value of the assets. Only debt relating to sharing assets is included in the calculation of liabilities. However, a spouse may include debt that we characterize as pertains to the distinctive property if the value of the proprietary asset does not exceed the special debt. For example, if we're dealing with student loans or student debt, loose consumer debt, and the like. As a rule, the spouse's pension assets are not included in the divisions. If two spouses in a spouse have decided that they have a purely divorce, no division of property must be carried out, as each spouse take his or her estates out of the marriage. If a spouse entered the marriage with a company he or she should not risk to lose or make unprofitable by the divorce, the couple can make what we call a marriage agreement. When we're dealing with co-ownership and the housing division, it states that if an asset is owned by a spouse in a joint ownership, the asset will be included with half of its value in each housing unit. So to talk about the housing division from a more qualitative perspective, the practical division takes place by the fact that the spouse who has the asset in his or her area, for example, if he or she has brought into the property community either by the beginning of the marriage or during the marriage, has the priority over it. Personal items such as jewelry and clothing can be removed by the spouses who use them. These assets can thus be taken out before the net benefits are calculated. We thus have some exclusion rules. These are the crossing selection right. For example, if a family's home is owned by one spouse, which is not the one having the custody over the children, then the spouse with the children can have the property laid out in connection with the division. Then we also have some creditor protection. This is dealt with in paragraph 30. We have the unfair sharing paragraph, which we find in the paragraph 33, and then we have the abuse claim, which is in paragraph 40. If any of the exclusion rules are broken, there is the requirement for compensation, which we can find in paragraph 41. A spouse which also states a spouse who has helped to preserve or increase the other spouse's assets, which are not part of the division, including through taking care of the home, caring for the children, distribution of family expenses, and other similar means, may be awarded compensation. We also have the fairness compensation, which states that a spouse must not be placed unfairly in financial terms of a housing division. This is dealt with in paragraph 42 and 45.
Cohabitation. Two people are paperless cohabitants if they live together in a relationship that can be compared to marriage. There's not, as in marriage, a law that regulates paperless cohabitation. However, in various laws, there are individual provisions that relate to paperless cohabitation. For example, the Rental Act, the Heritage Act, and the Social Act. Unlike in marriage, in a paperless relationship there is no common property and rules for division when a cohabitation ends. Protection when selling or pledging joint housing, or automatic inheritance. The inheritance law contains provisions that make it possible to create an extended cohabitation will. This means that cohabitants can secure each other in the case of death, as if they had been married, and the parties would inherit each other. The inheritance between cohabitants, a resident tax of 15% must be paid if the cohabitation has lasted for at least 2 years, or the cohabitants have or are expecting children together. In case of shorter cohabitation, an additional tax is paid, so that a total of 36.25% must be paid. There is no tax to the state of inheritance between spouses. If a paperless cohabitating couple has one or more children, an extended cohabitation will be particularly important, as they do not automatically inherit one another.